Hi, very good morning. This is a Supreme Court judgment, very interesting and important judgment. Citation is Asia Sugar and Chemical Company versus State of Karnataka. This judgment is under erstwhile Sales Tax Act. Present GST also it will be applicable. Issue before the Supreme Court was retrospective validity of amendment withdrawing exemption. The recovery of tax, interest and penalty based on such amendment retrospectively. So very important. Facts. So briefly put, under the Karnataka Sales Tax Act, the commodity sugar was placed under the fifth schedule and was exempted from tax. Like GST Act, which contains several schedules prescribing different rate of tax. Sales tax also contained several schedules. Fifth schedule was exempted goods. Prior to amendment in 2001, so 2001 only amendment came. Prior to that, the entry used the expression sugar. That is the entry. It did not say sugar produced or manufactured in India or indigenous sugar. So traders were importing sugar and sugar was sold both interstate and also intrastate, within the state and outside the state. Original assessment were completed, accepting the exemption. So they grant the assessing officers accepted, yes, sugar is exempt. So they granted the exemption. By Act 5 of 2001, the entry was amended and the words produced or manufactured in India were added. That is, thereafter, after 2001, the entry read as sugar produced or manufactured in India. But what the government did was, this amendment was given retrospective operation. That is, only sugar manufactured or produced in India was exempted, even prior to 2001. That is what the amendment said. So imported sugar was subjected to tax retrospectively. Based on the amendment, reassessment notices were issued demanding huge tax from the dealers. Assessees approached the High Court challenging the constitutional validity. Single judge struck down the amendment, saying it was unreasonable. Division bench set aside the order of single bench and upheld the constitutional validity and retrospective operation of the Act. So on appeal to the Supreme Court. Supreme Court followed the following principles of law. 1. In taxing statutes, one has to look at what is clearly said. There is no room for intendment. Nothing to be read, nothing to be implied. Court is not entitled to fill up the gaps. The principle applies even to the entries given in the schedules. Where an entry describes a commodity in clear terms, court cannot expand that description by adding words. So court said if an entry is simply saying something, we cannot add or delete words. Simply put. 2. Second principle. Taxing statutes are not unconstitutional merely because it operates retrospectively. Where tax is invalidly imposed for want of power or some defect, legislature can remove the defect and validate the levy retrospectively. Third principle. Exemption granted in public interest can be withdrawn in public interest. No assessee can insist continuation of concession contrary to policy. The fourth principle. Retrospectivity, though permissible, is not immune from constitutional scrutiny. Question is whether retrospective operation is unreasonable or not. These are the four principles Supreme Court applied to this case. Then Supreme Court considered the entry sugar. The contention of department was that sugar was described by a reference to first schedule to additional duties of excise, goods of special importance act, and hence imported sugar is excluded. So if you are not a tax person, don't get confused. Simply the word sugar was there. According to them, that sugar, it has reference to additional there is another act called Additional Duties of Excise Act. So we refer to that. That means it is only a domestic sugar. Supreme Court said the expression as described merely identifies the goods. It does not impose an origin-based limitation. A statutory entry may incorporate a definition from another act for certain purposes. It may incorporate entire scheme or it may merely borrow a description for identifying a commodity. The answer depends upon the text, context, and purpose of incorporation. State's contention that imported sugar did not bear additional duties of excise in the same manner as domestic sugar, it may furnish a reason why legislature later chose to amend the entry. If the exemption was confined to domestic sugar, legislature should have said so in clear terms. To accept the argument of the state, it will be reading words which were not there in the entry. Hence, Supreme Court held prior to Act 5 of 2001, imported sugar was covered under the exemption entry. So clear. Validity of Act 5 of 2001. Now, Supreme Court checked the second aspect. Supreme Court said power to grant exemption includes power to withdraw or restrict the exemption. Public interest and revenue considerations. So, revenue consideration also you note. Public interest and revenue considerations may justify withdrawal of exemption. Based on the above reasoning, Supreme Court rejected the contention of the assessees that the amendment is beyond legislative competence. So the third question, whether retrospective levy can be enforced without qualification. Supreme Court said the more difficult question is not whether the law is valid or not, but how far its retrospective consequences can be enforced. State contended that once the amendment is valid, all reassessments made are also valid. Assessees contended that retrospective levy should not be there, it must fail. Because we have not collected tax under the sales tax like GST. If the product is exempt, you don't collect the tax. If the product is subject to tax, you collect the tax and pay it to the government from the purchasers. You collect the tax from the purchaser and pay it to the government. So assessee said, no, I have not collected the tax because of the exemption. So don't give retrospectivity to the amendment. That is what they argue. Supreme Court said neither extreme does complete justice to legal position. This is not a case where a levy always existed and a procedural defect alone was cured. This is a case of, Supreme Court says all these things. This is a case of withdrawal of exemption retrospectively. In sales tax law, the dealer cannot go back and recover tax from purchases. He cannot collect tax due to the exemption. Having said this, Supreme Court said state is entitled to determine and recover the principal tax liability, if any, upon lawful reassessment and computation. So Supreme Court says you can, in spite of the dealer having not collected the tax, you can recover the principal tax liability. Even though it was retrospective, even though the dealer has not collected tax, even though the dealer has complied with the exemption which was present at that time. On penalty, Supreme Court said penalty presupposes culpability, default, deliberate breach, or at least a failure to comply with existing obligation. It would be contrary to basic notions of fairness to impose penalty on a dealer who did not collect tax because it was exempted at that time. With regard to interest, Supreme Court said interest is compensatory in nature. It compensates the state for deprivation of money. But where the liability itself is created retrospectively, where the assessee could not have collected tax, levy of interest operates punishively. So hence Supreme Court held The validity of amendment but retrospective operation of law was prevented as far as the levy of interest is concerned. Dealer acted in accordance with law as it stood at that time. Hence, Supreme Court said no penalty can be imposed for pre-amendment period. Interest can be levied only from the date of lawful demand raised pursuant to reassessment after giving effect to the order of Supreme Court judgment. That means what? So with Supreme Court judgment, they can again reassess the dealer. They can collect the tax. Interest, if you don't pay within the particular period prescribed in the notice or in the demand order, you have to pay interest also. Till such time, you need not pay. My comments were, for me, the judgment is slightly confusing. Supreme Court says prior to Act 5 of 2001, sale of imported sugar is exempted. Legislative amendment is valid. Fact remains dealers have not collected tax. Supreme Court also accepts this position. Amendment is not a clarification or curing a defect in the law. That is also accepted by Supreme Court. What is the supervening public interest in which the exemption was withdrawn is not stated in the judgment. Even recovering the tax from the dealers who obeyed the law standing at that time. At that time, imported sugar was exempt prior to 2001. Is it not punishing a dealer for obeying the law? I obeyed the law. But still you are saying, no, no, you can recover the tax. Where will I recover the tax? Because the purchasers will not pay now. I have to pay out of my packet. If a trader collects the tax, in spite of the exemption granted, suppose tomorrow the government may withdraw. There are a number of exemption entries, even under the GST law. Now, if I collect the tax, 18% tax I will collect. I will keep it in your account. Government will punish me because your products are exempt, but you are collecting tax. It's violation of law. I will punish you. If a trader complies with the tax law granting exemption, so I don't collect the tax. One fine morning, after several years, government at its sweet will, because the power to grant exemption has the power to withdraw the exemption also. They will amend and remove the exemption and start recovering tax like this from the hands of the dealer, where the dealer will go. Huge loss of money when he was prevented from collecting tax from the purchaser by law. It is out of my packet. Direct hit on his belly, according to me. And I don't want to say more because in this case, it is not a tax imposed already, and there was some confusion in law. So the state entered and then rectified the mistake. It is not such a case. Clear exemption, which was withdrawn, no supervening public interest has been set in the judgment. Hence, I can't say more on this. Only God can save the traders. Have a great day.